Meeting to order. Welcome to meeting number 13 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of Thursday, March 31st, the committee is meeting to study Bill C5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. Today's meeting is taking place in hybrid format. Pursuant to House Order of November 25th, 2021, members are attending in person in the room and remotely using the Zoom application. The proceeding will be made available via the House of Commons website. I'd like to now welcome our witnesses, but before they begin, I just want to let you know you each have 5 minutes to, each group will have 5 minutes to make their opening statements, and then members will have questions. I don't have a time card, but when you're 30 seconds short, I'll kind of wave an envelope in the air, just giving you a heads up that it's about 30 seconds, and then I'll have to interrupt you, unfortunately, when your time is up, just to make sure all the members get their time. So to begin, I'd like to, I think we have 3 witnesses in the first round. We have Michael Spratt, who's a partner at AGP LLP Criminal Trial and Appeal Lawyers. We have from the London Abused Women's Centre, Jennifer Dunn, and from the Saskatoon Tribal Council, we have Chief Mark Arsand, Tribal Chief. So I'll begin by having Michael Spratt for 5 minutes.
Thank you very much, and thank you for the invitation. It's a pleasure to be back before the committee. My name is Michael Spratt. I'm a lawyer. I'm certified as a criminal law specialist by the Law Society of Ontario, and I'm a partner here at the criminal law firm of AGP LLP here in Ottawa. I've served on the board of the Criminal Lawyers Association. I've acted as vice president of the Defense Counsel Association of Ottawa, and I've been practicing in the trenches of our courts for about 15 years now. So I'd like to touch briefly on the 3 main features of the bill, and I'll start with minimum sentences. In criminal justice policy, the embrace of mandatory minimum penalties is a sentencing tool that is the hobgoblin of small minds. The evidence is clear. MMPs are an ineffective and dangerous tool. They don't deter crime. They don't increase public safety. They disproportionately impact Indigenous and other racialized Canadians, and they're incredibly expensive. In 2005, the Department of Justice found evidence that minimum sentences are not effective at deterring crime. In 2007, the Parliamentary Information Research and Service Department cited numerous studies which came to the same conclusion. And in 2017, the federal government report concluded that research in both Canada and the United States has found no evidence that mandatory minimum punishments have deterred crimes. Rather, they say, some studies suggest that MMPs can result in overly harsh penalties and disparities, that they increase the cost to the criminal justice system as a result of higher levels of incarceration, and that those lengthier sentences may actually increase recidivism. Expensive, racist, ineffective, unfair, and cruel. That's why time and time again, minimum sentences have been declared unconstitutional by our courts. It is a very positive step that Bill C5 removes this corrosive sentencing policy from the criminal code. But, of course, Bill C5 does not remove all minimum sentences. We need to eliminate every single minimum sentence in the criminal code. And I'll answer the question in advance. Yes, including for murder, which is a particular concern for women who have killed their abusers. Here's your history lesson. The only reason the minimum sentence for murder was found to be constitutional by the Supreme Court in the case of Luxon was because there was a possibility of review through the faint hope clause, which of course has now been repealed. At the very least, this bill should be amended to allow an escape valve for the rest of the MMPs that aren't explicitly eliminated. And there should be a requirement that all reasonable sentencing alternatives be explored and considered before mandatory minimum penalties are imposed. I'll move on to conditional sentences. This is one of the best parts of the bill. The amendment to the conditional sentence regime here is desperately needed. The amendment here is going to bring consistency in the application of the criminal law across Canada. Different provinces now have different conditional sentence rules because of different court findings. And on the ground, we see that conditional sentences bring efficiency and fairness to the justice system. Some people, and I'll be blunt because I normally am, members of the Conservative Party have said that conditional sentences are too lax. Now, just because a conditional sentence is available doesn't mean that it's going to be imposed. Conditional sentences can be imposed only for sentences that fall under 2 years and only when there's no danger to the safety of the community. Conditional sentences provide significant restrictions, denunciation, and deterrent. If you thought that mask mandates were an oppressive restriction that deserved and called out for massive protests, wait until you hear about conditional sentences, because they can be more restrictive and more punitive, but they can also be rehabilitative. Unlike traditional jail, conditional sentences come with strings attached. House arrest. Offenders can be required to take counseling, seek employment, perform community service, and make reparations to the victims of their offenses. This is one of the best parts of the bill. And very briefly, in the time that I have left, I'm going to deal with the drug amendments. Canada is in the grip of a deadly overdose epidemic. In 2020, more people died in British Columbia of drug overdoses than car crashes, homicides, and suicides all combined. Since 2016, more than 20,000 Canadians have died of opioid overdoses. Incrementalism is not enough here. People do not lead incremental lives, and they're not dying incremental deaths. The harms of continued criminalization are real. This legislation, as it pertains to this drug issue, is window dressing. It's the same type of window dressing that we saw in 2018 with legislation that sought to divert administration of justice defenses through police diversion. That power has been used 4 times by the police in Ottawa. The real solution here, and I'll just take 1 minute, just 1 second. The real solution here is not to give more power to the police, but to take it back. We need decriminalization and safe supply legislation.
Thank you, Mr. Spratt. I'll now go over for 5 minutes to Jennifer Dunn of the London Abused Women's Centre.
Thank you, Chair, and thank you to the committee for inviting me here today. It is nice to see you all again. My name is Jennifer Dunn, and I am the Executive Director of the London Abused Women's Centre, or LOC, here in London, Ontario. LOC is a feminist organization that supports and advocates for personal, social, and systemic change directed at ending male violence against women and girls. Our center is non-residential. We are an agency that provides women and girls over the age of 12 who have been abused, assaulted, exploited, trafficked, or experienced non-state torture with immediate access to long-term woman-centered counseling, advocacy, and support. On April 8th, the Honorable David Lametti said, quote, "Community safety is what we want. These reforms will make it happen," end quote. We do partially agree with the Honorable Minister. Community safety is what we want. However, we do not believe that Bill C-5 is what will make it happen the way that it is. There are 2 issues I want to address today. 1, conditional sentencing, and 2, mandatory minimum penalties. I'll start with conditional sentencing. With Bill C-5, the court may, for the purpose of supervising the offender's behavior in the community, order that the offender serve the sentence in the community. Some of the offenses listed in Bill C-5 are sexual assault, criminal harassment, kidnapping, trafficking in persons material benefit, and abduction of a person under 14. Women and girls are 5 times more likely than men to be victims of sexual assault, and sexual assault is a violent crime on the rise in Canada. With conditional sentencing, many women will be stuck in the community with the offender, which places them at even higher risk. A conditional sentence does nothing to stop an offender from continuing to commit violence. Women need the courts to see this. Conditional sentences for these offenses undermines the seriousness of these crimes. I have a quote here from a woman I am proud to work with. Her name is Caroline. Caroline is a peer support worker and a survivor. Quote, "I know a case where 2 men got 4 years, and for trafficking, that's nothing. When a woman has to face a lifetime sentence after being trafficked, many women will never get over it, and at minimum, those women face years and years of counseling and constantly watching their backs." End quote. We know from our work that the best predictor of future behavior is past behavior. Victims and perpetrators live in the same communities. An offender being placed back into the community with a conditional sentence is not always the answer. The second issue I want to address with you today is the repeal of mandatory minimum penalties for some offenses in the criminal code. I urge the committee to think about the most marginalized individuals when considering if this is good enough. Repealing some mandatory minimum penalties over others does not help with public safety, and women are not protected by the law unless all mandatory minimum penalties are considered. For example, a mandatory life sentence for women who end up convicted of murder in situations where they were reacting to male violence is inappropriate. Each year, 40 to 50% of women sentenced to life in prison are Indigenous, and 91% of them have histories of physical and sexual abuse. Canada's longest mandatory minimum penalty, the mandatory life sentence for murder, has resulted in countless miscarriages of justice for women. It has been proven time and time again that there is not a full understanding of the impact of violence against women in the criminal justice system. When listening to the previous sessions of the study, I also heard more than once that there are cost savings with Bill C-5, and I ask if the cost savings should actually be a point of concern when we are discussing the lives of women. We need systemic change. We need to protect women. Women deserve to live free from violence, and the courts need to see women are easily placed at more risk. On Wednesday in the Senate, while speaking about a different bill, Bill S-205, Senator Pate said, quote, "Let's ensure that we address the issues, attitudes, and ideas that fuel misogynistic violence in society and our criminal, legal, and penal systems while simultaneously implementing the sorts of robust social, health, and economic support systems that can truly assist women to avoid and escape violence," end quote. This could not be more true for Bill C-5 as well. In conclusion, we know Bill C-5 is an attempt to tackle systemic racism in Canada's criminal justice system, but the committee must remember that many of the victims of these offences are also part of the most marginalised and vulnerable. The government has a responsibility to make decisions based on the best interest of all. Thank you.
Thank you, Ms. Dunn. I next go to Saskatoon Tribal Council's Chief, Mark Arsand, if I said that right, hopefully.
Tansei Nanaskamin Kakio, my name is Mark Arkan. I'm the Tribal Chief of the Saskatoon Tribal Council. I'm taking this call on Treaty 6 territory in the city of Saskatoon. In regards to Bill C-5, I want to be very clear, mass incarceration of Indigenous peoples, period. It's a strong statement, but it's an accurate statement. As of December 2021, 32% of federal people in federal prisons were Indigenous, a new historic high. Over the last decade, the number of Indigenous federally sentenced women increased by 60%, rising from 168 in March of 2009 to 270 in March of 2018. Indigenous women account for nearly half of women in federal prisons, yet represent fewer than 4% of the Canadian women. Those numbers are astonishing, they're repulsive, and they're unacceptable. Then we look at the youth incarceration. In the city of Saskatoon, we have our one youth facility. 98% of the youth of female are Indigenous inside of that one facility. That leads to the correctional system, the provincial correctional system, then the federal penitentiary. These are things that are, when you talk about Bill C-5, I agree with our previous speakers that talk about the violence against women. That's never taken into consideration in the MMPs. When we look at all of these things, it's, Bill C-5 fully repeals only 13 out of 73 MMPs. That's less than 1 in 5 MMPs. Fully or partially repeals only 20 out of 73 MMPs. That's less than 1 in 3 MMPs. Addresses only 10 out of 28 MMPs that courts have found unconstitutional. That's only about 1 in 3 unconstitutional MMPs. This is not in line with the call of the federal government to repeal all restrictions on the use of conditional sentences and MMPs, in line with the TRC calls to action 30 and 32. Calls for Justice 5.14 and 5.21 of the National Inquiry into Murdered and Missing Indigenous Women and Girls, and countless other sentencing and law commission reports. In particularly, Criminal Codes 718.2E, mandatorial requires judges to consider an individual's Indigenous history and consider all reasonable alternatives to prison when determining a sentence, including options for treatment in the community. MMPs can prevent judges from carrying out this duty to acknowledge and reduce redress racism and colonialism. When we talk about all of these things, it's very important when we also look at the National Inquiry into Murdered and Missing Indigenous Women and Girls, stressed that mandatory minimum sentences are especially harsh for Indigenous women and girls. The TRC, a failure to provide sufficient and stable resources for the community and treatment programs that are necessary to implement GLADU and IPELI, helps explain why those decisions have not slowed increasing Aboriginal overrepresentation in prisons. Bill C-5 is a baby step in the right direction, but must be amended to be a good step forward. For any MMPs that are not repealed by Bill C-5, an amendment could be added to the bill to ensure that judges have the discretion to not apply MMPs if doing so would result in injustice. In appropriate, exceptional cases, judges would have to be able to consider lesser sentences, including alternatives to prison, such as community-based and culturally appropriate treatment options. And this is why today, I apologize for myself not wearing a shirt and tie for the House of Commons, but I had to make a statement about residential schools in the orange shirt that I'm wearing, of all the harms that have done to Indigenous people. And when we talk about MMPs, these are things that have to be really considered in regards to the sentencing of individuals from minor crimes to major crimes like murder. We have a lot of our Indigenous women that are in self-defense mode, then they end up spending a life sentence because of the abuse that they've endured by their relationship, and it's unacceptable. Judges have to have the ability to make those decisions by hearing the evidence, not following MMPs all the time, because moving forward, it's not acceptable. Even when we look at simple drug charges, we should be asking our people to be sent to treatment based on the residential school systems and the intergenerational trauma. It leads to all the negative impacts of people. In the city of Saskatoon, where I work, 80% of men, and I've talked about the young women, in one correctional system, 80% out of 450 people. That's a high number. Then they graduate to the federal penitentiary, which we have a higher number in the federal penitentiary. And this is just in the province of Saskatchewan. Imagine those numbers across Canada. And we have the lowest percentage. Thank you very much. Nanaskaman.
Merci.
For your test. The first round of questions. Our first question will be from Mr. Moore, and it's for 6 minutes.
Hey, thanks, Mr. Chair, and thank you to our witnesses for taking part in the study of Bill C-5, formerly Bill C-22. Many good points have been raised. I will encourage you, Mr. Spratt, since you mentioned conservatives, if you take the time to research the origins of most of the mandatory minimum penalties that are being repealed here, you'll find direct links back to previous Liberal governments, including the government of the current Prime Minister's father. So by no means are the mandatory minimum penalties in the criminal code there just by virtue of conservative governments. Although having been part of the former conservative government, I'm very proud of the measures we took when it came to conditional sentencing, because one of the key responsibilities of us as parliamentarians is to put in place legislation that creates balance and has a justice system that's balanced and protects the rights of not only the accused, but protects society and protects victims and respects victims and their families. And that's what we were finding with conditional sentences in the past, that too often something very serious in the community was being, the punishment being meted out was the offender to serve their time in the community. There's times when that's appropriate. There's times when it certainly isn't appropriate. So my question to you, Ms. Dunn, is appreciated your testimony. Section 718 of the Criminal Code cites that one of the main objectives of sentencing is to promote a sense of responsibility in offenders and acknowledgement of the harm done to victims and the community. You mentioned victims in your testimony. Bill C-5 expands conditional sentencing, like house arrest, to individuals who are found to have benefited financially from human trafficking. And we've spoke a lot about human trafficking. It's a scourge on our nation and internationally. We've heard very compelling testimony at this committee of the tragedy that is human trafficking. What message do you feel it sends to Canadians, and particularly to women and girls that you mentioned, that people benefiting from human trafficking would be allowed to serve their sentences home in their community?
Thank you for the question. So I think when we consider human trafficking as a conditional sentence based on the section of the code that you mentioned, it really undermines the seriousness of this particular crime. We know that where we are located here in London, Ontario, for example, we are considered a hub for human trafficking. A lot of human trafficking happens right here in our city and up and down the 401 corridor, the highway that goes from Windsor all the way up through to Northern Ontario. And the problem is that when you have an individual who has a conditional sentence and is put back into the community, oftentimes women are faced with having to face the offender as well. And it's so harmful. We see time and time again where women will come into our center and they can't even use their real name. We have to meet them outside of our center because they can't be seen to be in our parking lot with our signage because of the very dangerous situation that it puts them in when an offender is not, maybe in jail or is left back in the community. And so it really puts women at a higher risk, and it makes women have to watch their backs wherever they go. And I think that quote that I gave from my colleague Caroline speaks to it exactly. Women are left to pick up the pieces. Women are left to come to a center like ours and seek counseling.
Thank you. I appreciate that statistic that you mentioned. I was reference a report published by Statistics Canada said women were violently victimized at a rate nearly double that of men in 2019. But the report goes on to say that the discrepancy between male and female victims was largely due to the fact that women were over 5 times more likely than men to be a victim of sexual assault. And I know that you deal with your organization with the fallout of these statistics, and you are able to put a name to the stat. And I think sometimes when we're in these committees, we hear stats, but we forget that there's a person behind them. Could you tell us, in the consultations you've had with the people that you work with, how Bill C-5 could in fact fail Canadian women, and what we should do maybe instead to make a community safer, rather than eliminating the inability of offenders to get conditional sentence, and now being able to serve their sentence from home for some of these very serious offenses against women?
Thank you for the question. So I think when we're talking about sexual assault, the first thing that comes to my mind here is how dangerous it is for a woman to even get to the point where she's ready to report a sexual assault. And it takes so much courage on her part to even get to that point, knowing that you're going to be wrapped up in the criminal justice system for a long period of time, have to potentially face your accuser in court, have to have your voice there for testimony, and the list goes on and on and on. There are so many reasons why it's. Oh, okay.
Sorry, thank you, Ms. Dunn. Your time is up. Thank you, Mr. Moore. Next, over to you, Mr. Naqvi, for 6 minutes.
Thank you very much, Mr. Chair. Mr. Spratt, welcome to the committee. It's good to see you. I was hoping you'll make it down here in person, just down the street. You call MMPs, I'm just recalling your words, ineffective, expensive, and racist, I believe. And I think you wrote an article back in July of 2020, Lawyers magazine, are on the same lines as well. Can we talk about the ineffectiveness first? And if you can share with the committee, what do you mean by MMPs being ineffective? I recall reading in the article that you had spoken about how they actually increase crime rates as opposed to reducing crime rates.
That's right. I mean, the proponents of minimum sentences say that they deter crime, that the main good that they do is that they show how serious we're taking crime and or the offense, and it will stop people. Because of course, punishment after the fact, the harm's already been done. The main thing about minimum sentences is, yes, it increases prison populations. Yes, it's expensive, but and it takes time in court, but it will stop people from committing crimes. And that's not how deterrence works. That's not how people are deterred. If you are committing crimes because you don't care or because you have a mental health issue or an addiction issue, deterrence does not work. And so just jacking up the penalty doesn't stop people from committing crimes, but a sentence like that, in addition to the unfairness that can result, the cruel punishment in some of those more unusual cases, some cases that may fall outside the norm, that have compelling facts behind them, the increase in sentence can actually cut people off from communities, can crush an individual. And that is part of the reason why we see rates of recidivism, people committing crimes again, actually go up when we see sentences imposed under the minimum sentence regime.
You've written in the past, and I think you spoke to it today as well, and calling MMPs as a racist policy. Can you elaborate on that and explain how you have arrived at that conclusion?
Yeah, there's a number of systemic issues, and we certainly have seen the mass incarceration of Indigenous individuals and racialized individuals. There's a number of reasons for that with minimum sentences. Number one, it relies on prosecutorial discretion sometimes about whether minimum sentences are followed through in or not. And if you are a white, upper-class individual, you're much more likely to escape a minimum sentence by having the prosecution in a non-reviewable, non-transparent situation not proceed in that minimum sentence. We often see people induced to pleading guilty when there's minimum sentences, and that often falls on the back of those who can't afford lawyers and those who have more contact with the police. A lot of these minimum sentences, especially for drug offenses, fall disproportionately on individuals who are in over-policed communities. It's not because those communities necessarily have more, quote unquote, criminals in them. It's that the police are there and they're not in, Rockcliffe or Rosedale looking for the same offenses. And so it's a number of those systemic reasons that that minimum sentences operate in a systemically racist and discriminatory way.
I want to turn to conditional sentencing order, CSOs, and the way I see them is restoring discretion to a judge as one of the tools in the sentencing tool. Do you agree with that, number one? And number two, in what circumstances do you see CSOs being used in a criminal matter?
I'll give you one example. And I mean, Mr. Moore talked about balance, and having hard and fast rules that prevent something isn't balance. That's unbalanced. And that's why these minimum sentence or the restrictions on conditional sentences have been found unconstitutional. In one of my cases, I represented a very young black man. He was found with a gun, and he wouldn't have been eligible for a conditional sentence under the old legislation, but he was because it was found to be unconstitutional. He had no record on bail, or a minor record. He was on bail for over 2 years on house arrest. He had engaged in the community. He had made contacts with culturally appropriate rehabilitation efforts. He had taken responsibility. He had done everything you would want someone who has made a mistake to do, recognizing the harm that he has caused on his community, and also, taking into account his cultural background. We had a enhanced pre-sentence report that dealt specifically with systemic discrimination in the community that he was from. He was granted a conditional sentence. house arrest, reporting to a judge, constant monitoring, making sure he followed through on programming. It is a harsh sentence, and maybe even a longer sentence that he would have got if he just got a jail sentence. But this is a man who now is going to be able to contribute and be reintegrated, rather than a man who is going to spend 2 years or longer in jail, learning the exact skills we do not want to teach young men who have made a very tragic mistake.
Perhaps in situational circumstances where there are there are little to no public safety concerns, where you perceive CSOs to be used?
That's right, and that's statutory. There can't be any public safety concerns, and it has to be a sentence under 2 years. So you cannot think of the most heinous crime and say that person might be released on a conditional sentence, because that is not what is prescribed in the legislation, and that is not what a court would do.
Thank you.
Thank you.
Thank you, Mr. Naqvi, and thank you, Mr. Spratt. Next, we'll go to Mr. Fortin, Monsieur Fortin, for 6 minutes.
Merci, Monsieur le Président. Ma question.
Thank you. My question is for Mr. Spratt. I understand your concern, Mr. Spratt. On the negative effects of mandatory minimum penalties, and if there wasn't, probably the judges in many cases would arrive at the same conclusions. There would be large sentences handed down when the crime justifies it. But my issue is not really with that issue of the opportunity or not of having mandatory minimums. It's the message that we're sending out here. Would you agree with me, Mr. Spratt, to say that the legal system, it's a little bit like the spine of society? This is why people don't start killing themselves, and you go before the courts and you ask a judge to solve a problem if there's a problem. And right now, people are very concerned with the increase of violence with weapons or firearms. Mrs. Dunn was testifying, and she was saying that she's very concerned with regards to abolishing mandatory minimum sentences. So these are concerns on some level maybe irrational, on other level not. So yes, of course, it's the work of the judge is to hand down a sentence, but for the legislators, we have to make sure that the population will have confidence and trust in the legal system at the very heart of our system in society. So aren't you not concerned that by abolishing mandatory minimum sentencing, that we're sending out a message to the population that's not really important? These crimes are not really that serious. And you were talking about murder, and you were saying that we should abolish mandatory minimums even for murder. And I was talking about firearms offenses. To commit an offense with the use of a firearm, this, to me, seems unacceptable. Don't you fear, Mr. Spratt, of the message that this would send out to the population, of the impact this would have on the trust with regards to our legal system?
The criminal justice system and legislation like this is a very blunt tool to deliver a message to the public. More concerning to me has been the politicization of criminal justice over the last number of years, the ignoring of evidence. The message is sent to the public by virtue of the fact that things are criminalized. And in most cases, even when there is no minimum sentence, or even when there is a minimum sentence, if there is a very serious crime, the sentence is usually in excess of that. Quite frankly, dealing with firearms, the die's been cast. The Supreme Court has found the law to be unconstitutional. And it's unconstitutional for good reasons. And so while you look on one hand, potential speculative possible harms about the public getting the wrong message. On the other hand, there is the injustice that existed through the imposition of the mandatory minimum sentences. The public is capable. the Canadian public is capable of understanding nuance if you speak to them like adults. We can take crime seriously without taking discretion away from judges, and we can make sure that appropriate and when appropriate, very lengthy sentences are imposed. And at the end of the day, I hope that you would be guided by the research that whether it's a communications tool or not, increasing sentences through the use of minimum sentences doesn't actually make the public safer. That's what you should be telling the public. And I would hope that if you accept that evidence, and I submit you should, given the decades of testimony that committees like this have heard on the topic, that the public not be lied to by saying you'll be safer with longer sentences, that you engage in the harder work of ensuring that the public is made safe through appropriate measures that are grounded in evidence and that actually work.
Mais présentement, là, Monsieur Spratt, on a des mères de famille.
Yes, but we have mothers that are scared of sending their children to school because there are firearms. And so C5 sees that even to commit a robbery with the use of a firearm, we would be removing mandatory minimums. I understand what you're saying. Among jurists, we can talk about a lot of things, but we're working to serve the population, yourself, myself, and everyone here. And for the general population, when you say if you commit an armed robbery, we decide that today it's not as severe as it was, and we're taking away the mandatory minimum. And if you say, oh, well, it's a mandatory minimum, this creates an issue, and the sentence in any case will be the same, you can explain that, but the message is perhaps not the message that we want to send out to the public. So don't you think that the timing is really bad and that abolishing, well, of course, there are some mandatory minimums that we can abolish, but others, for example, armed robbery, well, we should keep mandatory minimums in cases such as those, for very severe cases.
The problem with mandatory minimum sentences is that they are a one-size-fits-all solution. So yes, armed robbery should be taken very seriously, and it is. I've represented dozens, if not hundreds of individuals who have been charged with serious offenses, including armed robbery. Those individuals all go to jail, and usually for a lot longer than the mandatory minimum sentence. The problem with the mandatory minimum sentence is that the hunter who has an unlicensed firearm, who is technically not in compliance with the law, can also be captured by that minimum sentence. And that's not a good situation.
Thank you, Mr. Spratt. Next, and thank you, Monsieur Fortin. And now we'll go to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I do want to thank all the witnesses for being with us this morning, my time. The government says that one of the purposes of C5 is to address the problem of systemic racism in the justice system, so I want to extend particular thanks to Chief Arcand for being with us and stress the importance of Indigenous voices and hearing Indigenous voices in our considerations. And I want to thank Chief Arcand, I want to thank you for bringing our attention to the facts about over-incarceration and the very shocking figures that you've cited from your community. Obviously, it's an injustice, but could you tell us a bit more about the impacts of over-incarceration in terms of the connections to family, connections to community, and connections to culture that result from this over-incarceration?
Well, thank you very much for the question, Randall, and I probably think this is probably the most important question. I was hoping somebody was going to ask this. So when everybody talks about MMPs, I'm going to be honest, it doesn't matter which government is. What happened to Indigenous people through residential schools and everything else, through the federal government, through the churches, through everything, who's holding them accountable? Because the people we're talking about right now is the Indigenous people that are being incarcerated through that system. And there's no MMPs and no accountability to that structure whatsoever. So I challenge the governments on this, both governments, and saying, what is the responsibility? So now you look at the Indigenous people that has been caused by all of these effects of what we just talked about, incarceration, breaking up families. Yes, I hear the questions about armed robberies. Those are severe, but what's the symptom to that? Why are people doing those things? Because of the way they've been treated by these systems imposed by government, where there's no accountability to the federal government. to the churches. Nobody's being held accountable for the murders of those families, for taking our children away and wondering why mom and dad are so messed up because their children have been taken away from their arms. No accountability. So let's be honest and start talking the truth here about how it destroyed the indigenous people of this country. And nobody's addressing that. And that's racism. That's systemic racism. And I think people have to be challenged. And I think it's the right thing to do, because when we talk about everything, this is why we have so many people incarcerated. Our families are destroyed. And when you talk about people going to jail through MMPs, where's the rehabilitation? Show us the stats of how many people have been rehabilitated through Indigenous people once they leave those MMPs. The answer is probably minimum. Right now, through the work that I do in the city of Saskatoon in the correctional system, we are trying to prevent people from going to the federal prison by rehabilitation, through education, through family unification, through employment, to get them a different way of doing things. So I want to thank you, Randall, for that question, because it's a very important question, and there has to be some accountability here, because we're dealing with a crisis of Indigenous people that are incarcerated, especially the women. The women are being abused every day. And if you don't know a woman that has been in an abusive relationship, they don't want to speak the truth because they're afraid. Nobody is helping them. Where's the rehabilitation to that? And they lead to violent crimes because they're protecting themselves. And that's all defense. So thank you for that question, Mr. Garrison.
Thank you, Chief Arcan. Can I say, would it be fair to say that what you're really telling us is that over-incarceration is a result of the residential school system and other pieces of systemic racism in society, but it also extends those impacts to another generation?
Absolutely, 1,000%. I agree with you, because it's the trauma that's been affected when you see people that have been taken away from your arms, and you have the RCMP of back in the day supporting this. If you don't give us your children, we're going to send you to jail. There's no accountability. And that's exactly what I'm talking about, is because I only have 6 minutes to address this. It's a lot to say, but that leads to all this destruction. We talk about gang violence. Why are people in those situations? We talk about all these severe crimes. It's because of the impacts of residential schools. It's destroyed families. It's a really bad situation. And now as leaders, as communities, we're creating partnerships and relationships to deal with the trauma from all of these systemic racist situations, which I call, we have to change the systems in order to get trauma and treatment for people. We lack treatment facilities. If somebody's getting caught with drugs, why are we sending them to prison to be recruited? Why can't we send them to a treatment facility to deal with the underlying issues? Nobody's addressing that. Maybe that person has ADHD, FASD. Those things have never been addressed. And this is what I'm working on, to actually address those situations, because we need to heal people. We don't wake up every day as Indigenous people say we're going to go kill somebody. That's not our thing. There's situations that happen to our people. They see violence every day. They see their mother, their father. They see all of that domestic violence. It's got, a system has to change, and we need this type of MMPs to be addressed.
Thank you once again, Chief Arcan. Can I ask you very specifically about one of the things I think we pass over too quickly, and that is, after being over-incarcerated, those who get out have criminal records. And can you talk about the obstacles that presents for people in terms of housing, employment, and rehabilitation to having a criminal record?
Very quickly, Chief Arcan.
Thank you, Randall. I wish me and you could have a conversation, because you're on the same page. So every day I deal with people that can't get jobs because of their criminal record, because people aren't understanding why they made these choices. Now we try to rehabilitate them. And when they get into the system of incarceration, there is no rehabilitation.
Thank you, Chief Arcan. Hopefully, you'll be able to explore it in the next questions. We're over to the next round, which are for 5 minutes. We'll go to Mr. Barrett for 5 minutes.
To Mr. Cooper, please, Mr. Chair.
Yes. Thank you, Mr. Chair, and I will direct my questions to Ms. Dunn. It has been asserted by this government, as well as other witnesses who appeared before our committee, more specifically the Canadian Bar Association, that with respect to the expansion of conditional sentencing, orders, that all this will do is allow so-called non-violent offenders to serve time in the community rather than behind bars. What do you say to that?
Thank you very much for the question. Well, first of all, I don't particularly understand how an individual charged with trafficking for material benefit or an individual who is charged with sexual assault could be considered non-violent. It doesn't make sense to me. Sexual assault and trafficking are a public safety issue, just by nature of what they are, and when you have individuals in the same communities as one another, especially if you think about maybe the Indigenous communities or the Black communities where police response time is already a cause for concern, it's a very big red flag. And it's not fair to women and girls that we provide service to. It's not fair to women and girls who have not yet sought out our service.
Thank you for that. And you mentioned that in terms of your center, there are many women who are at risk, who seek help, and they're afraid as a result of a violent offender, someone who poses a risk to them, being out in the community on a conditional sentencing order. And yet, under the criminal code, a judge must be satisfied that there isn't any public safety concern. So how do you square that in terms of what the law provides for and what is in fact happening in reality?
Thank you again. So I think we need to, this is way bigger than today, and it's much bigger than this bill by itself. I think we need to talk about the issues, the systemic change that needs to happen before this hits court, before we're talking about it in this situation here today. We need to talk about public awareness and education to children, boys and girls, as young as, goodness, I have children, I have twins that are 7 years old, and I talk to them all of the time about how to treat other people. And it needs to start that young. I mean, we need to look at what is best for all and the systemic change that needs to take place before it gets to the point that we're talking about today.
And I appreciate that, and I think that is absolutely valid. But what we have before us is a very specific piece of legislation that we are studying that expands conditional sentencing orders for, as you appropriately noted, some very violent offenses that surely are perpetrated by violent people who commit such offenses. And so, based upon your experience being on the front lines, is it your view from your experience that this legislation is actually going to put vulnerable women at even greater risk?
Thank you again. I think that this Bill C-5 needs to be broken down a little bit more. I do believe that changing the conditional sentencing does put women at greater risk. It puts them in harm's way, and it puts them in the communities where the offenders are going to be. And just because somebody is convicted of a crime doesn't mean that it's going to stop the violence from happening.
How much time do I have, Mr. Chair?
You have 30 seconds.
Okay, I will just ask Ms. Dunn if you have any concerns with the rolling back of the mandatory jail sentences relating to some very serious firearms offenses. You seem to, in your testimony, have indicated some level of support, but I find that a little bit confusing in light of some of the other testimony that you have provided.
Yes, I understand how that would be confusing. I think what we would present is that the committee needs to look at this with a lens of violence against women.
Done. We're over
Sure.
time. Hopefully, you can extract it on the next question. Next, for 5 minutes, for Madam Diep.
Thanks very much, Mr. Chair, and thank you very much to all the witnesses. Chief Arcand, let me go back to you. I think you sort of were interrupted by the timing for the last questions, and I really appreciated when you said that we need to heal people. You know, and then you ended with people who have criminal record come to you. Can you go back to those two in light of the mandatory minimum sentence and in light of the non-discretionary effects that they have on judges in sentencing Indigenous people, but quite frankly, all people, regardless of and again, we have it on record that that offenses that carry more than 2 years are not included in minimum, would still carry 2 years plus. Discretionary of judge are still there. They can give people way more than 2 years or more than the minimum mandatory sentences. But can you go back to sort of where you were trying to take us to?
Well, thank you for that question. You know, this is real stuff. For people that don't understand and you don't do this work every day, seeing the rehabilitation of the trauma enforced, it's all because of a system of systemic racism that has been dealt to Indigenous people. Now, here's two key highlight cases that I think when we talk about fairness between a non-Indigenous person and an Indigenous person, when we're going through the court system. Colton Boucher, killed by a non-Indigenous farmer. What happened to him? He was acquitted by an all-white jury. Even the First Nations people couldn't become jurors. A system that has to change. Yes, we're doing our best to do that, but why does it cost the life of an Indigenous person? You look at the Neil Stonechild inquiry of the Saskatoon City Police back in the day 20 years ago, right? We are being targeted as Indigenous people, and there's no, those sentences should be carried as life sentences, but because they have the money, they have the power, those are not carried out. But you look at an Indigenous person that gets charged, man, sent to jail, sent to prison because they can't afford the best lawyer, they can't pay for this this kind of stuff. Michael Spratt hit it right, the nail on the head. This is the reality. And where's the fairness and justice? When you talk about rehabilitation, the reason why our people are committing these crimes as Indigenous people is because they've been tortured and traumatized by a system. That system is through residential schools, and it leads to incarceration. And I say this honestly and openly. When you haven't dealt with people sitting in an office like we are, and being out there inside of that correctional center and that federal prison and talking to these individuals and saying they want to change because they don't like this life, it's not they're doing this and waking up every day. It's because they have been traumatized and nobody's supporting the trauma to stop them from doing this. Imagine if we took the 80% away from the incarceration system. There'd be no workers for CSO officers inside of the facilities. 98% of youth female. We wouldn't have a youth female jail. Doesn't that make sense to anybody?
Chief, thank you. I hear you. I have a question to you, Mr. Spratt, and if we have time, I'll also ask the Chief the same question, and that is in regards to the faint hope clause. Would you recommend or support reinstituting that and alter, or would you suggest any changes from the previous faint hope clause that was repealed by the previous government? Can you just give us a little bit of insight on that?
Yeah, it's something that most definitely should be reinstituted. The weight of the legal community, academics, scholars, people who practiced, recognize the importance of that clause, as did the Supreme Court in finding the parole and eligibility periods for murder constitutional. It is a faint hope, but hope is important. And when governments take the perspective that we need to build more jails, lock people up for longer, throw away the key, it is a damning admission of failure. And it is something that I would urge the government to readdress.
Chief, do you have anything to say on that particular point?
I would agree, just because I think the system has to change. And when you talk about that, let's focus on rehabilitation or prevention. How do we prevent somebody from being charged? And if it leads to that hope clause, then so be it, right? If people are convicted, then what's the rehabilitation mechanism? We've got to have those investments in there to really focus on these situations, because all I keep hearing about is the serious crimes. Well, how did we get to those serious crimes? If that hope clause is something that's going to do all that, I'm in full support. Thank you.
Thank you very much.
Thank you, Madam Diab. Next for 2.5 minute rounds, and that'll conclude this. To begin, Mr. Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. My question is for Mrs. Dunn. Mrs. Dunn, I understand, following your testimony, the concern that you share, and I'd like to hear your opinion. You heard Mr. Spratt earlier tell us that even for a murder offense, in his opinion, we should eliminate mandatory minimums and allow the judge to determine this appropriate sentence. Well, this might be logical, but Mr. Spratt was giving the example of a woman accused of murder for having killed her violent partner, and said perhaps the mandatory minimum sentence will create a prejudice towards this woman who is a victim herself. So I'd like to hear you speak to this. So should we remove mandatory minimum sentencing for some crimes? Not that they're less serious. It's always serious when there's a crime committed, but if I think of armed robbery, extortion of funds with a firearm, traffic of firearms, these seems to be very serious, and for me the MMS should be maintained so that the population will trust the legal system. But on your side, given what Mr. Spratt was telling us with regards to a situation, he was evoking the situation of a woman who have been accused of killing a violent spouse. Don't you think that we should abolish mandatory minimum sentences in some circumstances?
Thank you very much for the question. I think that there are no simple answers for this to be able to answer this in 2 minutes here. But what I do believe is that it needs to be looked at from the lens of violence against women. And I urge the committee to take a look at the case of Helen Naslund. And that might provide you with some answers on your question, sir. I believe that repealing some mandatory minimum penalties over others does nothing for public safety. I believe that all of the mandatory minimum penalties should be considered with the lens of violence against women.
Thank you. You've got 5 seconds.
Merci, Madame Dunn.
Thank you, Mrs. Dunn.
Thank you, Monsieur Fortin. And now for 2.5 minutes to Mr. Garrison.
Thank you very much, Mr. Chair. I want to return to Chief Arcand and ask a somewhat leading question. I think there's a kind of popular opinion that criminal records somehow keep the public safe. And this bill doesn't have a provision which I think might be quite useful, and that's for the automatic expungement of criminal records for personal possession of drugs, so that, say, after a year, those criminal records would be erased. And so, Chief Arcand, my question is: would a provision like this, what kind of impacts would a provision like this have in your community?
Well, I think, thank you for the question. I think if we focus people on sending them to treatment as their punishment, it's going to help them deal with their trauma. So when you talk about expunging their criminal charge after 1 year, they should be able to complete that sentence and follow the guidelines. That's going to make them better to make better choices so they don't get into that situation. And you'll see more success in people. It's like a second chance for those kind of charges that will stop them from simply crossing the border to take their family to go across into the United States, right? So things like that will really benefit the program. But I think sentencing them to try to get help with that addiction is going to really benefit our society and our communities.
Again, thank you very much for your testimony. I want to take the last minute I have here with Mr. Spratt. And Mr. Spratt, you really, I think, told us at the beginning that you think C5 is not a real response to the opioid crisis, and that you're looking to see the government do something more comprehensive when it comes to addressing that. Is that correct?
That's right. Giving the police more discretion, we've seen that doesn't work. We've seen that through the 2018 legislation meant to deal with administration of justice offenses. And I've talked to individuals who I talked to a young woman on our podcast who lost her brother. He was charged. That charge may have been diverted, but because he was charged and it was dealt with through the criminal justice system, he wasn't able to get into treatment. And he later died of an overdose. The act of the criminalization, even if there's a diversion option down the road, is a harm in and of itself, and we need to move towards decriminalization and safe supply. Too many people have died.
So we will, of course, as members of the House of Commons, have a chance to address decriminalization and safe supply in a private member's bill from Gord Johns that's going to come to a vote in about 3 weeks in the House of Commons. In the last 30 seconds we've got here, can I ask you about...
we're past time. Sorry, Mr. Garrison.
Okay, thank you.
You're welcome. Thank you, Mr. Garrison. I want to thank all the witnesses for your very valuable testimony and your time and commitment to show up and give your thoughts and your insight. I will now ask the clerk to suspend for a few minutes just for sound checks, and the witnesses are dismissed. You're more than welcome to stay and watch, but I think from this video presentation, you'll be dismissed, and we'll welcome the other one. So we'll give it a minute or so until the clerk lets me know we're good to go. Thank you.
Thank you.
I want to welcome you all back. I want to welcome the next round of witnesses. I think we have Andre Gelinas, detective retired from the Intelligence Division of the Service de Police de la Ville de Montreal. We also have from the Canadian Association of Black Lawyers, we have Raphael Tachi, President, and Jacqueline Beckless, Secretary. We also have from the HIV Legal Network, Sandra Kahonchu, welcome back, the co-executive director. So each group will have 5 minutes to give an opening statement, and then there'll be a round of questioning. I'll raise a green folder when there's 30 seconds left in your time, just to give you a warning to wrap it up. And if not, I will unfortunately have to interject at the end. So we'll begin with 5 minutes to Andre Gelinas, please.
Bonjour, Monsieur le Président.
Hello, Mr. Chair. The current position of this bill is in fact an acknowledgement of the failure of successive governments and social services in our country. It's also an incoherent attempt to cover up the criminal reality by trying to make it disappear. They're trying to put the onus on judges to reduce the number of people from Black, Aboriginal, and marginalized communities by encouraging them to be lenient. This is not an appropriate way to reduce their presence in the prison population. The role of the courts is to apply the law and to make sure that it is applied equally to all. And that's why this statue representing Madam Justice wears a blindfold. She judges the facts alone. It's not her role to lower statistics, costs, or proportions, or even to care about this. For police and society, a criminal is a person who does not respect the minimum rules that it has given itself and who compromises the security, development, and well-being of citizens. He's not a patient or a client as he can be for other entities. The criminal code doesn't make you a good or a nice person. It's the absolute minimum that must be respected to function in society. As we say in Latin, the malum in se, the evil in itself. The bill is nothing more than a race to the bottom. The message is, if you can't meet the minimum requirements, we'll lower them so you won't be held accountable for your actions. These put the lives of citizens in danger because we're talking about firearms. As we know, especially in the police force, the number of illegal firearms is skyrocketing. These are virtually the only weapons we find in our seizures, in our crime scenes. And the more illegal guns there are, the more they will be used for the very crimes that this project is about and committed by members of criminal organizations, including street gangs. Violence and the use of firearms is the basis for the control of a territory or an illicit activity, such as prostitution, sale, production, and importation of drugs. This is why various criminal groups and their members are what they're doing in perpetuating the criminal acts covered by this bill. What needs to be understood is that the current problem is the users of these weapons. It's not hunters or sport shooters. It's the street gang members or other members of organized crime. They're particularly resistant to attempts at social reintegration because of the intrinsic workings of their criminal organizations. It's false and naive to believe that a criminal can absolve himself from outlaw motorcycle gangs, street gangs, or different types of mafias. Crimes allow individuals to progress in a criminal organization, to climb the ladder, and to position themselves as violent leaders. They are the preferred way to promote themselves in the criminal underworld by using firearms. For them, violence is everything. Rehabilitation is possible for some criminals with some problems. That's not the case for the users of firearms in their exercise of their crimes because they're working for criminal organizations to protect or make their illegal and extremely lucrative activities prosper. To hope to counter this, we must act upstream. I encourage you to listen seriously to what the police will tell you about the total lack of coherence and deterrence in this project. The police have an overall vision, and contrary to what some may think, they are very lucid. We see the criminals and the victims. We see the devastating results of these illicit activities committed with illegal firearms. Sometimes we walk in the blood of their victims. We hear their cries when they are frightened, injured, or dying. We console their families, their loved ones. Our 360-degree view is the most complete that can exist. No other profession has such an insightful and broad view of the crime situation. It's interesting to note that the groups that demand the relaxation of the laws are generally the people who are the furthest away from the commission of the crime, from the victims, from the violence. We are privileged witnesses because of our missions and our work. We don't read about this in a report or see it on TV. It's a paradoxical to think that abolishing MMS or criminal firearms offenses will have a beneficial impact on our communities. We are facing a significant increase in the number of shootings in major cities like Montreal and Toronto. The answer proposed by this bill is to abolish mandatory minimum sentences to satisfy the appetite of certain ideologues. This will only add to the arrogance of the very criminals who commit the very acts that this bill seeks to target. There will be no deterrence. It is as if, in the face of a significant increase in school dropout and graduation rates, the strategy would be to lower the passing grade on final exams. It defies logic. The message this sends to the police who confront these criminals is one that will only feed the discouragement and disengagement they've been suffering for years. The same assumption could be made for the Crown prosecutors. This does not bode well for our collective security. As a society, we're facing an abdication and a retreat that's certainly not a solution to the overrepresentation of the communities targeted by this bill. Finally, I would like to point out that nowhere in the bill is the word victim mentioned. Thank you.
Monsieur le Président, je ne vous entends pas.
I don't hear you, Mr. Chair.
So to Mr. Tachi or Ms. Beckless?
Hello, good afternoon, Chair and honorable members. Thank you for inviting the Canadian Association of Black Lawyers to share our views on the bill. My name is Raphael Tachi. I'm the president of the Canadian Association of Black Lawyers. I'm here with my colleague Jacqueline Beckles, the secretary of the association. I want to highlight that a lot of the comments I'm about to give has been the result of the impressive work of Ms. Beckles and our Criminal Justice Reform Committee. But more importantly, it is a reflection of our lived experiences as Black people in Canada. And when I hear the phrase, removing minimum mandatory sentences, the request to remove those are made by people who are further from the crimes. I'd like to highlight that many victims of crimes tend to be also the same people from the communities that are faced with overrepresentation of in the criminal justice system. We appreciate the opportunity to speak to you today, and our comments around Bill C-5 is really structured around three issues. We generally, our comments focus on the request that when considering criminal justice reform, we encourage the government to look at the stages prior to sentencing. At the sentencing stage, the competing priorities need to be balanced, including community safety. There are significant strides that can be made much earlier, such as in diversion, that lead to the ultimate over-incarceration of members of the Black community in the criminal justice system. Our comments are focused in three areas: mandatory minimum sentences, conditional sentences, orders, and then evidence-based diversion. With respect to mandatory minimums, the proposed Bill C-5 proposes to repeal a number of mandatory minimum sentences, especially the 4-year minimum mandatory minimums. While those are really laudable goals and we are encouraged by them, the 5-year minimum sentences will remain where a restricted or prohibited firearm is used or where the offense is committed in connection with a criminal organization. This includes cases where an offender is the subject of party liability, whether or not that weapon was in that particular offender's possession. This result, the only avenue available to an offender is to avoid, in order to avoid a minimum sentences, is if a prosecutor acting in their prosecutorial discretion agrees to resolve the charges by accepting a plea of lesser offense. What this really means is that for a Black accused, you have to plead guilty in order to avail yourself of the opportunity to avoid a minimum sentence. In order to address this possibility and in order to uphold judicial discretion, CABLE recommends eliminating all mandatory minimums for drug and weapons offenses. I heard Chief Arkan speak and the other panelists earlier speak about how mandatory minimum sentences restrict judges from imposing appropriate sentences on individuals and can prevent judges from really taking relevant factors like systemic anti-Black racism into consideration. Judges have been elevated to perform an essential function within the criminal justice system, and they should be afforded the full discretion to perform that function, especially as we work really hard to make sure that the judiciary reflects the community in which they serve. Mandatory minimum sentences often hamper real justice from being done. When they're included in legislation, the justification is usually because of deterrent. But many research has shown that these sentences do not often achieve that result and do not impact crime rates. The second issue we'd like to talk about is conditional sentencing orders. They're essential tools for combating recidivism as they can allow for offenders to maintain familial ties, employment, and school commitments. Chief Arkan spoke about being holistic in our approach. We agree entirely with that, and that a focus on keeping these ties is really a focus on promoting the social determinants of justice, making sure that offenders have the ability to recover from what might be a one-time mistake. Removing the limit formerly found at Section 742 sub C and expanding the application of conditional sentence orders is a very good step in the right direction. However, we're mindful that given the historical application of CSOs, that it is important to reinforce that a CSO can be imposed where the court is satisfied that a service of of a sentence in a community will not endanger the safety of the community and will be consistent with the fundamental purpose and principles of sentencing. Including this language in and enforcing this language with respect to the bill will reduce arbitrary limits to their use, such as requiring an offender to have an employment in order to be considered for a suitable for a CSO.
Thank you, Mr. Tachi. I'm going to have to cut your time, but hopefully you'll be able to answer it in one of the questions. Next, for 5 minutes, if I can have Sandra Kahanchu from the HIV Legal Network.
Thank you. Thank you to the members of the committee for inviting us to speak about Bill C-5. I'm the co-executive director of the HIV Legal Network, and I'm presenting today on behalf of my organization and the Center on Drug Policy Evaluation. Today, I'm going to focus my remarks on the section of Bill C-5 that pertains to evidence-based diversion measures. But before I begin, I'd like to endorse the recommendations made by the previous speakers calling for the restoration of conditional sentences and the repeal of all mandatory minimum sentences. Or in the alternative, an amendment to Bill C-5 that ensured judges retain discretion to not apply mandatory minimum sentences if doing so would result in injustice. So turning to the evidence-based diversion measures. In this section, despite acknowledging in its Declaration of Principles the need to protect the health, dignity, and human rights of people who use drugs, the stigma associated with criminalization, and that judicial resources are more appropriately used in relation to offenses that pose a risk to public safety, Bill C-5 stops short of repealing Section 4 of the Controlled Drugs and Substances Act. This failure to eliminate criminal sanctions for drug possession completely undermines the principles underpinning the bill. From 2014 to 2020, police in Canada made more than 600,000 arrests for drug offenses. 2/3 of those were for simple drug possession. Yet more than a century of drug prohibition in Canada has not had an impact on levels of drug consumption. As the Canadian Mental Health Association has concluded, contrary to the logic of criminalization, incarceration does not result in the cessation of substance use, nor does it prevent harm. As we outline in more detail in our submission, drug prohibition fuels stigma and discrimination against people who use drugs, and criminal records limit employment and housing opportunities, they affect child custody, and they restrict travel. The frequent contact that police have with people who use drugs leads to syringe sharing, rush injection, and isolation while using drugs, and creates barriers to accessing health services, contributing to epidemics of preventable HIV and hepatitis C infection, as well as overdose, which has resulted in nearly 27,000 deaths in Canada between January 2016 and September 2021. Considering the ample evidence demonstrating the harms associated with criminalizing simple drug possession, and consistent with Bill C-5's Declaration of Principles, Bill C-5 should include a full repeal of Section 4 of the Controlled Drugs and Substances Act. Short of such repeal, we recommend some amendments to the bill. In particular, Section 10.1 regarding the Declaration of Principles that explicitly centers human rights and does not frame drug use as primarily a health issue, acknowledges that most cases of drug use do not pose problems for the individual, and that pathologizing drug use actually contributes to stigma, referencing the harms of criminalizing necessity trafficking, because it is common for people to sell drugs to others in their network as a means of livelihood, to support their own use and to avoid withdrawal, or to provide a safe supply. And finally, acknowledges the disproportionate impacts of criminal sanctions on drug possession on Black, Indigenous, and other racialized communities, given the racist roots of Canada's drug control framework and the fact that Black and Indigenous communities in Canada continue to be disproportionately charged, prosecuted, and incarcerated for drug offenses. In Section 10.2, subsection 1, which outlines options for a peace officer who encounters someone in simple possession of drugs, an officer is required to consider whether it be preferable, having regard to the principles set out in this bill, to take no further action, to warn the individual, or with the consent of the individual, to refer them to an agency or service provider in the community. Despite this requirement, the subsequent section indicates that other charges, subsequent charges, are not invalidated if a peace officer fails to consider these options. We recommend deleting this paragraph altogether, as in practice, it will completely undermine the purpose of the bill. In Section 10.3, a prosecutor could, instead of laying criminal charges, opt for alternative measures, as defined in Section 716 of the Criminal Code. In the context of drug offenses, this typically includes drug treatment courts. But such courts have been critiqued for being coercive, ineffective, and posing numerous human rights concerns. They should not be presented as an alternative to decriminalization. And in Section 10.4, regarding a record of warning or referral, the police force may keep a record of any warning or referrals relating to individuals alleged to have committed an offense under subsection 4.1, the section that criminalizes simple drug possession. This provision is contrary to the spirit of Bill C-5 and the Declaration of Principles. Police record keeping would negatively affect the privacy of people who use drugs, could be used as a tool of surveillance, and undermine the potential to improve the quality of drug users' encounters with police. It is imperative that police not engage in monitoring, surveillance, and record keeping under the guise of reform or public safety. Therefore, we suggest replacing may with must not keep records. I want to conclude by urging this committee to reject incrementalism and take bolder steps with respect to Bill C-5 that will more meaningfully address systemic racism and the harms of drug prohibition, including a full repeal of Section 4 of the Controlled Drugs and Substances Act. Thank you.
Thank you, Ms. Kahanchu. Now I'll go to the first round of questions, beginning with Mr. Morrison for 6 minutes.
Okay, thank you, Mr. Chair, and thank you for the witnesses today for being here. We appreciate especially the diverse knowledge that's here. My question for Mr. Jelinas, and thank you for helping us focus on. Sometimes, to me, we get the victims and we also get the offenders, and sometimes to me it's the victims sometimes are just not as vocal because they've been involved in some heinous crimes where they just don't feel comfortable in talking about it. So thanks for bringing that up. And in law enforcement, I know that you're there right front and center, having to deal with the victims and dealing with the aftermath of a serious violent crime. It is interesting that you brought up the fact that organized crime, gang activity has almost always, I believe, and you can correct me if I'm wrong, is illegal guns. And yet here we are in the middle of not only this C-5 bill that we're reviewing, but also there's some other legislation coming up for the seizure of what some people have called weapons that are, or guns that are, look like assault weapons, but they don't specify or actually define that kind of a gun. But with illegal guns, and I know now in at Vancouver, which is an area I'm more familiar with, ghost guns are quite popular. Of course, they're just 3D printed, used 1 or 2 times. Have you ever, in your experience with dealing with organized crime, gang activity, do you deal with many people that are pals that actually have legal guns, or are you almost exclusively dealing with illegal guns? Oh, you're still muted, sir.
Désolé.
Sorry, Mr. Chair. What I would have to say on this is that, yes, members of organized crimes, mafia members, biker gangs, they almost exclusively, 99% of the time, are using illegal guns. It's not, there's no reason for them to use legal guns. Generally speaking, they don't have a permit, and it's too risky for them to obtain a firearm legally and to obtain a firearm legally in Canada. So seizures prove this, and experience and the contacts that I still have with my colleagues who are active members, the firearms that are killing and harming people in the streets of Montreal are illegal guns. It's extremely rare to see legally acquired firearms or stolen firearms to be used.
Okay, would you agree, sir, that with if we're spending millions, billions of dollars on seizing legal guns from legal gun owners, that funding might be more effective if it was put in towards law enforcement? I'm talking about serious organized crime, serious gang activity, in enforcing that, and also enforcing the illegal guns that are transported into Canada.
Oui, tout à fait.
Yes, absolutely. I believe that the debate is not the correct debate. The control of firearms in Canada is very efficient, I believe, for legal weapons. But the real issue, and where there's a problem, is the the amount of illegal guns coming in from the U.S. We have the largest border between two countries in the world, and there's a lot of arms possession in the U.S. So if we believe that the problem is coming from illegal weapons and firearms, the sums spent should be used to counter this, because experience shows us that the seized weapons after crimes that we find in the crime scenes in the possession of criminals are illegal guns.
How do you feel C5 is going to have an effect on future crime reduction or crime prevention, even with the illegal behavior with gangs and organized crime?
Well, listen, what we know is that increasingly criminals are very arrogant with regards to firearms. In the past, what we saw was that criminals, especially biker gangs, and they didn't carry firearms. They had bodyguards, same thing. The firearms were being toted around by people accompanying them. And now this is no longer the case. We can think that maybe because they're not scared of mandatory minimums, but no, that's not it. Criminals right now are very arrogant. They're so arrogant that the use of a firearm becomes practically a habitual thing for them. The way of controlling illegal activities, of controlling territory, this is through violence, and it's through firearms, because your enemies on the other side also have firearms. So this is the only way of setting out your territory, and when the leader is defined by extreme violence.
Thank you. Thank you, Mr. Morrison. Thank you, Mr. Jelinas. Next, for the 6-minute round, over to Madame Briard.
Merci, Monsieur le Président, et merci à...
Thank you, and thank you for all the witnesses who are here. My question is for Mr. Taki. I'd like to give you the opportunity to finish your comments and also to specify, when you were talking about abolishing mandatory minimum sentences, that this could be a promising thing, and that I would like for you to clarify your train of thought on this.
I would say my comments, for the most part, the last piece of it focused on this diversion, and Ms. Han Chu spoke really well, eloquently on that issue. So I won't repeat it. I won't repeat myself on that. It was actually a really great dovetail in terms of what I was thinking, where I was going. I apologize, I didn't quite get the second question.
Si vous pouviez préciser.
If you could clarify your thought process when you said that abolishing mandatory minimums was a promising thing, but that we had to declare the guilt of the offender.
Sorry, let me clarify. Sorry, let me. Sorry, I'm not sure what happened, but on my end, there's a weird issue happening on the sound. What I meant, what I was saying to that point was that in certain instances, you have to plead guilty before you can avail yourself to potential avoidance of the mandatory minimum. And so in requiring that, in putting that discretion with the prosecutor and not with the judges, what you're doing is really criminalizing the individual because they don't have the option of even pleading guilty because that bars access to avoiding the mandatory minimum. That is, with respect to abolishing all mandatory minimums, that really related to drug offenses and substance offenses, because in those instances, and Jackie's probably the best person to speak to that, what we're arguing for is that it gives the ability to really impose a conditional sentence and keep the familiar ties, that approach focuses on a similar holistic approach to how do we deal with these issues and individuals that find themselves here. Let's keep them in the community to the extent possible.
Et alors, quelle autre mesure devrait...
So the other measure should be used to combat systemic racism in the justice system and also to deal with or to help people who have mental health issues.
I completely agree. Jackie, I'll defer to you. I think you are much more the expert on this topic than I am.
So ultimately, if I may, ultimately what we're seeing is that the systemic racism that we're seeing endemic in Canada has to do both at the level of interactions within the Black community, as well as once individuals are brought before the court. And what we propose with respect to Bill C-5 in particular is the absolute repeal, as my colleague Mr. Tachi has said, the absolute repeal of mandatory minimums, because they don't serve the purpose for which they're intended. Within the Black community, because our communities tend to be over-policed, because we have seen carding in some areas, because we have seen that there is almost a circular logic that is applied to criminality within the Black community. Our communities are policed, and therefore offenses and offenders are located within the communities. They are disproportionately policed, and therefore we are seeing that a disproportionate number of Blacks and Indigenous individuals are being brought before the courts. And there, what we have seen is that the discretion that is usually exercised by both police or prosecutors is not exercised in favor of the offenders. So where there is discretion to issue warnings, for example, or to divert cases, we are not seeing that being exercised in favor of first-time offenders within the Black community. So they are then brought before the courts, and then they're in court. The prosecutor is similarly not exercising the same discretion to divert cases, to give individuals the opportunity to experience diversion or to plead guilty to lesser included offenses, for example. So they're facing prosecution for the most serious crimes, and the circular logic that I spoke of is as a result of this, because if you have, let's put a number to it. If you have 100 offenders, and of that 100 offenders in the white community, there would be a diversion of 63%, let's say. These numbers are accurate because our studies have shown that within the Black community, you don't divert as many as in other communities. So, and the numbers are quite significant. For the Black community, the diversion numbers are around 1/3 of individuals who come in, who are confronted by police, whereas in other communities, it's 2/3 of the individuals who will be diverted. So, out of 100 offenders, you might see 60 offenders diverted. In other communities. In the Black community, you'll see 30, which means you're bringing the other 70 offenders before the courts. What that does for judges and other members within the criminal justice system is the perception is that Black people are committing more crimes. And that is not, in fact, the case. It is simply that they are not being treated in the same way when they're intercepted or when they're interviewed.
Thank you, Ms. Beckles, and thank you, Madame Briard. Now over to you, Monsieur Fortin, for 6 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. My question will be for Mr. Gélinas. Mr. Gélinas, I was listening to you speak earlier as to the staggering increase of shootings in Montreal and Toronto. And I heard many witness testimonies to this effect. If you listen to the news, you can realize that this is in fact the case. And in C-5, as it is right now, we are looking at eliminating mandatory minimum sentences for many offenses, but there's one on the firearms trafficking. So not all trafficking, but some types of firearm trafficking would no longer be subject to mandatory minimums. I'd like to hear you speak on this. You were saying earlier that it's not logical, and this only encourages criminals. Or do you think it's acceptable in some cases? Once again, in the case of trafficking, answer: no. everything that has to do with firearms trafficking, whether it be near or far, has to continue to be subject to mandatory minimum sentences. Perhaps the person that is trafficking will not commit a crime with the firearm, but will allow other organizations and other individuals to use it. If a criminal is walking around with a firearm, well, there is an intention behind this, and these people are not in a possession of a firearm just for the fun of it. No, it's because they know that they could find themselves in a situation where they'll have to use it. Because the people that they're operating with, their rival gangs, even the police, because we are hindering their traffic or their illicit activities. So, of course, this is really serious. The person who is facilitating the obtaining of a firearm, in my opinion, in the opinion of many of my colleagues, is just as guilty, because this allows the commission of a crime. It opens up to the possibility of using a firearm to shoot someone. Ultimately, a firearm can be used to shoot and kill someone. And so there's no coming back from this. Thank you. Now, as for the offenses for which we're looking at withdrawing the mandatory minimum sentencing, as we were saying earlier, I don't really like to qualify less serious as some crimes, because in my opinion, a crime is a crime and it's always serious. But for some, the consequences are more disastrous, and I'm thinking here of extortion using a firearm, armed robbery, discharging a firearm with intent, as opposed to by accident, and arms trafficking. So this, to me, seems quite serious, and I would think that it would be a mistake right now to eliminate mandatory minimum sentences. But there are other types of crimes and offenses in the criminal code that are of a less serious nature. For example, discharging a firearm, but without any intent, accidentally or through imprudent use, possession of firearm, of a prohibited firearm, well, not for trafficking. So in some cases, could you consider it that it's acceptable to eliminate mandatory minimum sentences, or in your opinion, in every case, we should keep them as they are? Answer. As you were saying earlier, if you watch the news, you can see that the number of shootings is skyrocketing in Montreal and in Toronto. And so if we use this as a start point, the situation is getting worse. The danger is heightened. There is a greater number of innocent victims that are shot or killed. And yes, I mean, if we talk about armed robbery, extortion, discharging a firearm, you have to understand one thing, and that's this is a whole. If somebody's going to discharge a firearm, for example, if you talk about an imprudent discharge of a firearm, well, perhaps they're not aiming at someone, but I would like to talk about public safety and the feeling of public safety. People that are living in the neighborhoods where street gangs operate, where there's organized crime, the people living in these neighborhoods feel totally abandoned with this type of bill. For them, that the intention was there or not to harm someone with a bullet, well, the result is the same. And so these people want to leave their neighborhoods. They're afraid, and we're looking at an exodus from some neighborhoods. But unfortunately, people that don't have the means to leave, they are held hostage. They're held hostage by these criminal organizations. So I would say that a firearm, and once again, the use of a firearm is not an innocent thing. If a criminal is in possession of an illegal firearm, well, once again, it's not just for the pleasure of having it. It's because behind this, there is the intent to possibly use it. And it's a strong possibility. Thank you. And you said earlier that the firearms used to commit crimes are usually illegal guns. And you spoke to the importance of combating against illegal guns, do you think there should be a joint squad with members of the RCMP, Sûreté du Québec, the Ontario Police? Could this be a useful exercise in fighting against firearm trafficking?
And you there? Maybe you can answer that in a subsequent round, but you're up for time. Next, I'm going to go to Mr. Garrison for 6 minutes, please.
Thank you very much, Mr. Chair. And once again, I want to draw us back to the fact we're dealing with a bill that is supposed to be attacking systemic racism in the criminal justice system. So I'd like to direct my questions to the Association of Black Lawyers. Similar questions to those I asked Chief Arcand. Certainly, it's clear that over-incarceration is an injustice, but I'd like to give the association a chance to talk about the impacts on Black families and Black communities of over-incarceration. Either Ms. Beckles or Mr. Tackey.
Maybe I'll start, and then Ms. Beckles, I'll leave you some time. And in responding to that, I want to share my own personal story because of the comment that Mr. Jelinek was making earlier. I came to Vancouver. My family immigrated here when I was 13. When I turned 15, I was on a date in a movie theater on Granville Street. Granville Street used to have 2 small movie theaters. At the end of the movie, I walked out with my date and I saw maybe 10 Black kids. Half of them I knew, half of them I didn't know. I walked over there to say hi to them. And within 30 seconds of being there, we were all detained by the police. The first time I've ever encountered a police officer in Canada, handcuffed and sitting on the corner of a street on Granville with people walking by. Now, later on, I came to understand some of the people, the boys I had seen were involved in crimes and things like that. And some of them might have even had guns. Some of them might have even been part of gangs. But concepts such as party liability and mandatory minimum sentences and things like that swoop in kids that have bright futures and snuffs them out. In my case, the only reason I was able to avoid any connection to that was I had the person I was on a date with had privilege, and her father interceded on my behalf to say to with a VPD at the time, to tell them that I wasn't part of that group, that I was some kid that just came out of a date with the movie theater with his daughter. 15 years later from that date, I'm now the president of the Canadian Association of Black Lawyers. I'm a partner at a large national firm. I now lead a practice group. I now go out and motivate kids to tell them that law is an opportunity for them. These kinds of laws, mandatory minimum sentence laws, and grand statements about gang activities and neighborhoods and things like that, what they do is sweep up all kids, regardless of potential, regardless of ability, regardless of what the future holds for them. The reason why I'm here today is because of that. It's because of that encounter on that street corner on Granville that day. It reminded me that my potential could have easily been snuffed out because I happened to have crossed the street to say hi to somebody I knew. I want to stop there and give Ms. Beckles a chance to speak to the law, but narratives are powerful, and I wanted to show you that my narrative, my personal story is I'm a Christian and I grew up in a Christian faith, but it's by grace of God, I would be the person you're labeling as a criminal. I would have been the person you're labeling as a gangster, and my potential was so much more.
And if I may, I won't echo what my colleague Mr. Tachi has said, but what I will say in response to the honorable member's question is that I come from much of the same communities that Mr. Jelinek is speaking of. I grew up in Pierrefonds, and there was a shooting in Pierrefonds just this week or last week that I was watching on the news. And what I can say is that mandatory minimums do not make a community feel safe. I know this because I'm a member of the community. And what we are proposing with the repeal of mandatory minimums will not remove the ability for judges to impose what is a just and fair sentence. Let's keep in mind, where you have organized crime, where you have gangs, where you have crimes of a very serious violent nature, judges have the discretion to impose what is a reasonable and fit sentence in the circumstances. All we are proposing is that there not be a basement to what those reasonable and just sentences are, that the judges not be hamstrung in appropriate circumstances by imposing what is a reasonable circumstance. As the honorable member mentioned, there are certain of the offenses where mandatory minimums just are not reasonable, where there might be crimes of inadvertence, where there might be situations where the judge, in all of their wisdom, authority, and discretion, see that the mandatory minimum is simply too high for the circumstances. These are people who are appointed to this position, and we urge you to give them the authority to implement what is just and fair under the same laws that would see justice done. Thank you.
I think also what your testimony here today reinforces is the cruel irony that not only is over-policing and over-incarceration caused by racism, but it reinforces racism. Would it be fair to say that?
We will completely agree. It's what leads to over-surveillance. And then when you arrest more people, it's now the justification for saying why we need to over-surveil and why we need to keep people in jail. It's just Ms. Beckles spoke to it, a vicious cycle that just repeats itself.
Thank you very much.
Thank you, Mr. Garrison. Next will be a round of 5 minutes. I believe it's Mr. Cooper for 5 minutes, unless I'm mistaken.
Thank you. Thank you, Mr. Chair. Thank you to the witnesses. Ms. Beckles, in your last answer to the exchange that you had with Madame Briere, you had cited a number of statistics. Would you be able to provide the committee with the studies or documents that those statistics are based upon?
Yes, absolutely, and I'm happy to provide it in writing to the honorable members of this committee.
That would be very helpful. Thank you very much for that, Mr. Gélinas. We've heard from several witnesses today and a previous hearing that say get rid of mandatory jail terms, that they don't work, that they increase recidivism, that why not just let a judge fashion a reasonable and fair sentence, and that somehow mandatory jail time provisions prevent judges from doing so. Ms. Beckles just said that a few moments ago. I was wondering, given your extensive experience in law enforcement, what you would say in response.
I would say quite simply that the use of a firearm is a very serious offense. And as a society, we have to send out a very strong message, and that it is unacceptable. Listen, someone who is caught with a firearm, whether they've used it or not, as I was explaining it, there's an intention. There's an intention, whether it be latent or not, and this constitutes a huge danger. Imagine being the victim of a firearm crime, even if they're pointing a gun at you. I don't think that this is going to make you safer in your community to know that this person won't be subject to at least a minimum amount of sanctions. Yes, I do trust in the judgment of the judges, but at some point, legislators also have to send out a message to society and to judges that we consider that there is a threshold. The use of a firearm, for example, if you reach this threshold in your criminal activity, you've crossed a line. Of course, judgments evolve with time, either through doctrine, either through case law, where the different courts are linked. But as legislators, you have the power to send the message to the judges and the population that it is no. We see an increase in shootings everywhere, and the use of firearms is becoming something more common. People are not afraid to show photos of themselves on social media with firearms. And don't forget something. Whether it be from the arms trafficking from Indigenous reserves, the first victims are Indigenous people themselves. And for street gangs, I worked in street gangs, and oftentimes the victims are the people in their own neighborhoods. As legislators, you have to protect all of these people.
You're quite right that Parliament makes laws, not judges. And you cited at the end of your last comments victims, and at the end of your testimony, you noted that nowhere in Bill C-5 is the word victim mentioned. Nowhere in the Bill C-5 backgrounder on the Department of Justice's website is the word victim mentioned. Indeed, it's we ever hear members on that side utter the word victim. And in the 6.5 years that I've been a member of Parliament, I've talked to a number of victims, many victims, almost all of whom have been very, very disappointed with the approach that this government has taken in terms of their disregard for the rights of victims. Do you have any comments on that? Would you wish to expand upon the comment that you made at the close of your opening statement?
Yes, absolutely. When we're talking about the criminal code and we talk about criminal legislation, as I mentioned in my opening statements, the criminal code was set up to establish a minimum. This is the minimum that we need to work together in a society. And the criminal code was written to protect people. It's a protection. It's a protection that society has given it itself. It's a basic rules. Even if you respect the criminal code, you can be a truly awful person. But at the same time, you can function in society. And I think that this is important because the trust of victims, they have to trust not only the police, but also the legal system and also democratic institutions.
Thank you, Mr. Julius. Thank you, Mr. Cooper. The last 5 minutes for Mr. Naqvi, and then we just have some community business.
Very much, Mr. Chair. I want to go back to Mr. Tashi. Thank you for sharing the story you shared, and I'm sure quite a few members may relate to the circumstances that you described. It reminded me of consultations that I was holding on the practice of carding in Ontario, and hearing from 15, 16-year-old black boys who would be stopped by police, their school bags be checked, they'd be carded simply because they were just walking from school to home late in the afternoon, which we'll expect any child to do. So what you were sharing with us is real. That kind of racism is real, and the impact is quite real as well. I want to talk a little bit about conditional sentence orders that's part of this bill as well, and your thoughts and Ms. Beckles' thoughts on that, as to the kind of impact that could have on Black community, on racialized communities and Indigenous peoples, if that discretion be restored within our criminal justice system.
Thank you, Mr. Naqvi. I think Ms. Beckles is the expert on that, so I'll defer to her. My only slight comment would be from, and Chief Akan said this, and I'll repeat it because I'm really aligned with that, is to the extent our criminal justice system deals with, especially first-time offenders, by keeping them in close to their families, close to keeping familiar ties, access to education, and gives them an opportunity to really recover from what might be a one-time mistake. Those are important. That is the place we should start from. If you put somebody in jail and the ultimate result is they will return back, the community is not safer, especially if they're coming back worse than they were. But please, Ms. Beckles, go ahead.
With respect to community sentence orders, the first thing that we would ask you to keep in mind is that CSOs are a form of imprisonment. And although CSOs allow an offender to serve their sentence within the community, there are strict conditions and some which are statutorily required. So they ensure that an offender complies with the order, and they ensure that an offender is properly and adequately treated. So expanding the use of CSOs is actually helpful to both the community as well as the offender, and it serves more of a rehabilitative aspect, as Mr. Tachi was just alluding to. And we have to be mindful that since Black people who are subject to hypersurveillance and over incarceration, this can help serve both the double objective of rehabilitation and punishment where it is appropriate. CSOs also leave Black offenders vulnerable to mandated state surveillance and ensure compliance with conditions. So while we unreservedly advance and advocate for the position that an expanded use of CSOs is appropriate, we urge you to consider that it is still a punitive sentence, notwithstanding the fact that it's being served in the community. And if I can address just for a moment the comment that was made, or a question that was posed by Member Cooper, there is something to be said for the fact that what Mr. Jelena proposed, that often these crimes are being committed in the community and the victims are from the community. And there is something to be said for the fact that members of these same communities are coming to you, honorable members, to say, we would like to see the lifting of mandatory minimums. We would like to see the imposition of CSOs, because our communities are the ones that are affected. The Black community, the Indigenous community have unilaterally, have universally come to you to say, we don't want these in place. We are the victims. We are not standing on the side of only the offender. We are considering the true victims of the crime, which is our community, and are telling you, this is important to us. This is what we want to see. Thank you.
Thank you. Thank you to all the witnesses. Thank you to give your personal stories and your experiences and sharing that with everyone here today. So that concludes this part of the meeting. You're more than welcome to log off. We just have some members' business. Just a quick housekeeping. Just wanted to let everyone know that this study has about 3 more meetings for a total of 6, and then we move on to clause by clause for
Monsieur le Président.
meetings.
Mr. Chair, could we not have, we still had 2.5 minutes for myself, 2.5 minutes for Mr. Garrison, while the witnesses are still here. Could we complete these turns?
If I get the consent of all the panel, I don't mind extending for another 5 minutes. Do I have the consent of everyone? Seeing no objection. Yeah.
Hold on a sec, Mr. Chair. I thought,
sorry, Mr. Moore.
We're at the end of our meeting, and how long do you expect this committee business to last? I mean, we're
I'm done.
Well,
I just wanted to let you know about the meetings.
Well, unfortunately, we're not done because we've never agreed that we would only hear 6 days of witness testimony. There had been some proposal, I think, by Mr. Fortin that we have 8 days of committee testimony on this bill on C5, and I certainly support that and spoke to that last time. So we did not come to a conclusion on how many meetings we would have, and I would propose that we would have 8, but this is something that I would hope that we would set aside time for committee business, and we are at the end of our meeting, so.
I'm more than open. I just wanted to let you know that that's what I had so far. So if you want, I can convey with you, and maybe on Tuesday we can keep some time in with that respect. If you're okay with that, Mr. Moore?
Yeah, if it's time to discuss the total number of meetings, yes, that sounds good. And my proposal would be that we have 8. Thank you, Chair.
Okay, and I can't see the floor very well. I have no problem in extending for 5 minutes, but
Mr. Moore, I'm sorry, but I have another meeting to go to.
So unfortunately,
I don't know.
Mr. Fortin, I don't have consent to extend the meeting, and on my clock it was 12 o'clock. So
Ouais, vous avez raison, Monsieur le Président, mais à ce moment-là, je vous suggère.
You're right, but I would suggest that at the next meeting, instead of giving 2 times 5 minutes, that you give the first 3 minutes, and that we have a minute and a half or 2 minutes to Mr. Garrison and myself, because it's not really fair.
But I'm always very liberal with you, Monsieur Fortin.
You're always liberal, I know, but.
Since the witnesses are still there, if it's only me, I'll stay for 5 minutes.
Are we good? If I see a nod of heads, I'll do that real quickly. Sure. Let's continue. Monsieur Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you very much, Mr. Chair. And I would have 2 quick questions for Mrs. Hung Chu. I saw that when you were testifying, you read from notes and there were references to the criminal code, I believe, or perhaps other laws. Could we obtain a copy of this? This is my first question. And the second, I'm going to ask this right now. In your testimony, you spoke a lot about decriminalization. And in C5, this is a process of, it's a different process. So the offenses linked to drug offenses are still criminal offenses, but they can be dealt with in parallel with the legal system as a healthcare problem. So are you favorable to dejudicialization or not? Are you wanting to decriminalize, plain and simple?
Mr. Fortin, I believe it looks like she's not on the screen. Mr. Clerk, I don't know if you can. Ms. Hanchu is not, I believe.
No, she's disconnected.
Oh, okay, alors, sir, I will just take the last, I don't know, about a minute, I guess, que je pense que j'ai. Ouais, mais je vais aller avec.
Mr. Tachi, I was listening your testimony, Mr. Tachi, on a young black men who were stopped and handcuffed and sitting in the gravel. And of course, I find it totally unacceptable. This is not the society that we want to live in. But the question that comes to mind is this due to mandatory minimum sentencing, or is this due to the fact that there's a racist police officer for whatever reason that proceeded in doing abusive and useless arrests?
It's both. The issue is if black bodies are over surveilled and over policed, you're going to swoop in a number of people who are then going to be subject to the vagaries of the criminal justice system. So in my example, but for an intercession by somebody else that got me out of that system, I was arrested as a gang member. So if I'm labeled as a gang member and there's somebody in that group that had a gun, and we have concepts like party liability and things like that, what I was trying to get at is you've just pulled somebody who, for all intensive purposes, probably has a bright future into the criminal justice, and now you're adding labels to that person, and that impacts them going forward. That what you're doing is impacting the trajectory of people, whether they, regardless of the potential they have, regardless of whether their ability to speak for themselves. At a 16-year-old or 15-year-old, I didn't have the ability to articulate my positions the same way I can today. I didn't understand what I was involved in.
Thank you, Mr. Tachi. Now 2.5 minutes to Mr. Garrison.
Thank you very much, Mr. Chair. I want to turn to the Association of Black Lawyers again for a final question. This bill is prospective. It talks about eliminating things in the future, but certainly in the community at large, and in particular in the Black community, there are lots of people who already have criminal records for personal possession of drugs. So I wonder if either of our witnesses could speak to the role of expungement of those records in promoting rehabilitation and preventing reoffending and keeping communities safe.
Absolutely. Expunging a record gives an individual hope. It gives an individual the opportunities for the future. I, for example, am a public servant. With a criminal record, that may be possible, but without one, absolutely. I have the ability to get security clearance. I have the ability to travel freely. I have the ability to operate without scrutiny. And to a large extent, having a criminal record impedes individuals in their simple, basic efforts to maintain a life, sometimes to obtain proper housing, to maintain adequate employment. A criminal record is an incredible deterrent, and studies show that with a criminal record and as a Black person, you are actually 4 times less likely to be selected for an interview, much less obtain employment, which is significant within the Black community.
And can I ask just one quick question then at the end here about diversion? This bill offers more power to make decisions on diversion to police. And there have been some concerns expressed that in the absence of police reform, this may not have the intended impacts.
Yes, we share that concern. And one of the things that we would like to see whenever there is discretion, we would like to see parameters on how that discretion is to be utilized. We would like to see guidelines and appropriate training, which the Canadian Association of Black Lawyers is very willing to stand with the government around how to train, what issues, what factors need to be considered in the exercise of discretion. Because as I've said earlier, the exercise of discretion usually disfavors the Black community. So we want to see strict guidelines whenever something is discretionary around how that discretion is exercised.
Thank you very much. And thank you very much, Mr. Chair, for the extra time.
Thank you, Mr. Garrison, and thank you to all the witnesses once again, and thank you to all the members in the House for patiently waiting for a few minutes longer. The meeting is now dismissed. See you Tuesday.
Merci, Monsieur le Président.
Thank you, Mr. Chair.